CF 1991, appearances.
Paul Tiffin, appearing for the state.
Morning, Your Honor. Craig Powell and Michael Hart on behalf of Mr. Mattioli, who appears in person.
All right, good morning, everyone. Well, we're set today to continue with this jury trial. The jury is not yet in the courtroom. I just met with the attorneys to go over instructions final time. We completed a jury instructions conference yesterday off the record. Today, I want to first cover kind of the highlights of that discussion. The court did grant the state's request to include the lesser included offense in this matter. So the court will be reading instruction 1022 and instructing the jury on both first-degree reckless homicide and second-degree reckless homicide, again, as requested by the state. And as requested by the defense, the court is including instructions for 4 defenses, including under 772 for accident, 801 for self-defense, 825 for defense of others, and 880 for lawful actions of a peace officer. I've reviewed these draft instructions with the parties. Regarding your positions on the draft instructions. I'll start with the state, Mr. Tiffin.
They're acceptable.
Okay. And for the defense?
I'll note, as we discussed in chambers yesterday during the conference, that the defense is objecting to the inclusion of the lesser included offense in this case. We feel it's not appropriate or warranted under the law. Just for a complete record, our position is, of course, the standard is a lesser included offense should be submitted only if there's reasonable doubt as to some particular element included in the higher degree of the crime. The only difference in elements between first and second degree is the utter disregard element here. That element seems to me rests entirely on Mr. Mattioli's description of what occurred. That description was given to Investigator Dallin on April 19th, was in the state's knowledge when they charged this case and made their decision to charge it as first-degree reckless homicide. In my view, the evidence came in no differently than they had back then. And if the state, by asking for the lesser included, the state is saying to the court, it believes there are reasonable grounds to acquit on the utter disregard element based on the information that came out and that, again, it had before. And if the state believes there are reasonable grounds to acquit on utter disregard, then it shouldn't have charged first degree in the first place, but it made that election and they should be married to it. State versus Kramer, K-R-M-A-R, discusses how giving an unwarranted lesser included instruction creates a significant risk that a jury will convict on the lesser as a compromise verdict. And that, in my estimation, seems to be what is being put on the table for them, a way out for a jury who may not be able to come to a consensus on first degree. I don't think the evidence supports it, and so I think we oppose the inclusion of the lesser included offense for those reasons, Your Honor.
Thank you. Mr. Tiffin?
Judge, the process the court has to go through is a 2-step process. First of all, the court has to decide if the requested lessering substantive instruction is in fact a lesser included crime by statute, second degree, and also looking at the elements, second degree reckless homicide is a lesser included crime of first degree reckless homicide. Given that fact, then the question that the court has to decide is the court has to consider whether the evidence justifies the instruction. The court must weigh whether there is a reasonable basis in the evidence for the jury to acquit on the greater crime and convict on the lesser crime. Contrary to the defense arguments, this is not a statement that the state believes there is insufficient evidence. It is a weighing done by the court. The difference between the two elements, the two crimes, is utter disregard for life. That element is not, in the state's view, a separate and distinct element from the second element, whether conduct is criminally reckless. They sort of flow into each other, and it's for both of them, it's a function of the jury looking at the evidence and deciding, first of all, was the conduct criminally reckless, and if criminally reckless, was even more, was it showing utter disregard for life? Given these facts, there is a reasonable basis that a jury looking at this evidence could decide that Mr. Mattioli's conduct was criminally reckless, but not showing utter disregard for life. It's not the position the state will argue, but there is a reasonable basis, and that's what the weighing the court has to do. And under the law, given that situation, given the evidence that the court has heard, the court and the state's view of the evidence, this is appropriate to give a lesser included instruction, and that is why the state has requested it.
Thank you. And we discussed these arguments in chambers yesterday, and parties, thank you for putting them on the record. The court is relying on State v. Sarabia, that's S-A-R-A-B-I-A, at 118 Wisconsin 2nd, 655, Wisconsin Supreme Court 1984, which is the seminal case concerning this issue. And I'm quoting from Sarabia at page 663. The court held that the defendant or the state may request and receive lesser included offense instructions even when the defendant has given exculpatory testimony, if under a reasonable but different view of the record, the evidence and any testimony other than that part of the defendant's testimony, which is exculpatory, supports acquittal on the greater charge and conviction on the lesser charge. And then at page 661, the court, quoting from State v. Bergenthal, states that the court should, if requested, submit the lower degree as well as the higher under these circumstances. So I agree with the state that those circumstances are present here, that a reasonable jury could find that the state has satisfied its burden as to the first two elements of these two offenses, but not the third element of the higher degree of reckless homicide. And therefore, the court finds that inclusion of the lesser included offense is appropriate here with respect to instructions. Gentlemen, anything else? Mr. Tiffin?
No.
And Mr. Hart, Mr. Powell?
No, Your Honor.
Okay. All right, I'm going to ask the deputy to collect the notebooks since the jury will not be taking notes any longer. The testimony and all presentation of evidence has been concluded. We're going to start then with instructions when the jury arrives, and then we'll move into closing statements.
Your Honor, one thing, I'm sorry.
Yes, sir.
There's a microphone that's been placed on the jury box directly in front of at least one juror, maybe two. My view is that should not be there. I know there's immediate interest in catching the audio, but it's impacting the jurors directly. It's right in front of their face. I think it should be moved.
Right.
You know, we can probably put it on the ground.
Yes. Yep. Sorry, members of the media, we're going to have to move that microphone. I agree.
Thank you.
But yeah, thank you, Mr. Tiffin.
What's that?
Thank you for. And Deputy, you could bring the jury in, please. Thanks, everyone. Please take your seats. Morning, members of the jury. You'll notice we did collect your notebooks because at this time, the time for presentation of evidence has been concluded. You won't need to take notes from now on. I will start with instructions. You'll have a copy of these instructions with you for your deliberations. So again, you won't need to take notes during instructions. And then the parties will be presenting their closing arguments. And you can't take notes during those arguments because, again, those are not evidence. Those are argument. All right, we're going to start again with instructions. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. In this case, the state has charged the defendant, Mr. Mattioli, with one count. The first count of the information in this case charges that on or about Sunday, April 19th, 2020, at 4502 West Cleveland Avenue in the city and county of Milwaukee, Wisconsin, the defendant did recklessly cause the death of Joel Acevedo, another human being, under circumstances which showed utter disregard for human life, contrary to section 940.02 sub 1 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree reckless homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree reckless homicide, you must consider whether or not the defendant is guilty of second-degree reckless homicide, which is a less serious degree of criminal homicide. The crimes referred to as first and second-degree reckless homicide are varying degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. While the law separates reckless homicides into 2 degrees, there are certain elements which are common to each crime. Both first and second-degree reckless homicide require that the defendant caused the death of the victim by criminally reckless conduct. First-degree reckless homicide requires the state to prove the additional fact that the circumstances of the defendant's conduct showed utter disregard for human life. It is for you to decide of what degree of homicide the defendant is guilty, if guilty at all, according to the instructions which define the 2 degrees of reckless homicide. Self-defense is an issue in this case. In deciding whether the defendant's conduct was criminally reckless conduct, which showed utter disregard for human life, or was criminally reckless conduct, you should also consider whether the defendant acted lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. First-degree reckless homicide, as defined in section 940.02 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of Joel Acevedo. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm of another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element is as follows. The circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. The defendant contends that he did not act with criminally reckless conduct, but rather that what happened was an accident. If the defendant did not act with criminally reckless conduct required for a crime, the defendant is not guilty of that crime. Before you may find the defendant guilty of first or second-degree reckless homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the defendant acted with criminally reckless conduct. Defense of others is an issue in this case. The law of defense of others allows the defendant to threaten or intentionally use force to defend another only if the defendant believed that there was an actual or imminent unlawful interference with the person of Christopher Peters, and the defendant believed that Christopher Peters was entitled to use or to threaten to use force in self-defense, and the defendant believed that the amount of force used or threatened by the defendant was necessary for the protection of Christopher Peters, and the defendant's beliefs were reasonable. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in defense of others. You should consider the evidence relating to defense of others in deciding whether the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in defense of others, and you must be satisfied beyond a reasonable doubt from all the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. The use of force by a peace officer is an issue in this case. An off-duty police officer is a peace officer. The law allows a peace officer to use force in making a lawful arrest only if the defendant believed that it was necessary to use force to make an arrest, and the defendant believed that the amount of force used was necessary to secure and detain the person arrested, to overcome any resistance, to prevent escape, or to protect the defendant from bodily harm, and the defendant's beliefs were reasonable. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what an ordinary, prudent, and reasonably intelligent officer would have believed in the defendant's position, having the knowledge and training that the defendant possessed, and acting under the circumstances that existed at the time of the alleged offense. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant was not acting lawfully in the use of force to make an arrest. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Joel Acevedo by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the death of Mr. Acevedo was not an accident, and that the defendant did not act lawfully in self-defense, and that the defendant did not act lawfully in defense of others, and that the defendant did not act lawfully in using force to make an arrest, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should consider whether the defendant is guilty of second-degree reckless homicide in violation of Section 940.06 of the Criminal Code of Wisconsin, which is a lesser-included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that the first-degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, and that the death of Joel Acevedo was not an accident, and that the defendant did not act lawfully in self-defense, and that the defendant did not act lawfully in defense of others, and that the defendant did not act lawfully in using force to make an arrest, you should find the defendant guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Joel Acevedo by criminally reckless conduct, and that the death of Mr. Acevedo was not an accident, and that the defendant did not act lawfully in self-defense, and that the defendant did not act lawfully in defense of others, and that the defendant did not act lawfully in using force to make an arrest, you should find the defendant guilty of second-degree reckless homicide. If you are not so satisfied, you must find the defendant not guilty. You are not, in any event, to find the defendant guilty of more than one offense. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. The presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. You heard and viewed certain audio and video recordings. Recordings are proper evidence, and you may consider them just as any other evidence. Listen carefully, some parts might have been hard to understand. You may consider the actions of a person, facial expressions, and lip movements that you can observe on videotapes to help you to determine what was actually said and who said it. You were provided a transcript to help you listen to one audio recording. If you noticed any difference between what you heard on the recording and what you read in the transcript, you must rely on what you heard, not what you read. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must consider and determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. And whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement along with all the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness' conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness' recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and the weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. That concludes the majority of the instructions. I'll have a very brief closing instruction after the closing arguments. We'll start with closing arguments and the state. Mr. Tiffin.
As the judge told you in the instructions, what I have to say right now, what Mr. Hart has to say on behalf of his client is not evidence, they're arguments. Evidence finished yesterday afternoon when Mr. Mattioli left the witness stand. It began Tuesday morning when Mr. Peters took the witness stand. Everything that happened between those 2 points in time, what people said, what you heard, what you saw, that's the evidence. You take the evidence, you take the law which the judge read to you, and you have to make decisions. You have to decide whether or not the state has proven beyond a reasonable doubt whether Mr. Mattioli committed a crime and or whether or not his conduct was privileged. You know that Mr. Mattioli is charged with first-degree reckless homicide. That's simply a label the legislature chose to put on the crime. What's important is how they're defined. This is just a chart. You won't have this chart, but you'll have these words in the jury instructions. First-degree reckless homicide. We'll also have a choice of second-degree reckless homicide. As instructed, are degrees of homicide. They share certain elements in common, and the state has to prove them. One, that the defendant caused the death of Joel Acevedo. Cause means that the defendant's actions were a substantial factor. It doesn't require the state to prove that they are the only factor. They have to be a substantial factor. In this case, you know this. On the morning of April 19th, Joel Acevedo was walking, was talking, was moving, and was alive. When Robert Roach walked into that kitchen, Mr. Acevedo, his brain, didn't have sufficient oxygen. He was essentially pulseless and non-breathing. But for the paramedics resuscitating a pulse, he would have died there. He died 6 days later. What's the difference between those 2 points in time? Mr. Mattioli being on his back. Was Mr. Mattioli's arm around Joel Acevedo's neck a substantial factor? We'll never know because Joel can't tell you. I mean, I know Dr. Jensen takes the position there was no definitive pathological evidence of significant compression. Those were his words. That's true because there were no broken bones, there were no injuries to the muscles. That doesn't mean there was not some compression. And in fact, when being interviewed by Investigator Dallin, Mr. Mattioli's words were, "I didn't press hard enough." By saying I didn't press hard enough, it implies there was some pressure there. But what we do know is that you can get petechial hemorrhages. You can prevent oxygen from getting to the brain by being on the back of a person and crushing their thorax, their chest. And that's what Mr. Mattioli did. Andrew Janowski acknowledged that he told the police that Joel Acevedo had Mr. Mattioli's weight on his back. Dr. Jensen, Dr. Tlomak both said that action responsible for the lack of oxygen that caused the anorexic encephalopathy, the lack of oxygen to the brain. Officer Roach, who walks in, who's not intoxicated, sees this and sees Mr. Mattioli is not crouching and just sort of lightly. His weight is on Mr. Mattioli's back. The conduct of Mr. Mattioli that morning was a substantial factor. Was it the only factor? No. But it was a substantial factor. But for Mr. Mattioli's conduct, Mr. Acevedo would be alive. First-degree reckless homicide and second-degree reckless homicide also require the state to prove that the conduct was criminally reckless. Criminally reckless conduct means conduct. It's stated here, and it's in the instruction. It is conduct which creates a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created that risk. what you have in this situation, you have to look at everything that happened. You have a picture of an extremely angry man, Mr. Mattioli. That is obvious from the 911 call and his statements. You have a man who is intoxicated. You have a man who gets on the back of Mr. Acevedo when there was no apparent struggle and remains there. In fact, when the police pull up, the words out of Christopher Peters' mouth are, "We have him subdued in there." There's no struggle going on at that time. Mr. Peters has left. He stood outside. He's smoking a cigarette. He knows that he's already subdued. Does Mr. Mattioli get off? No. He remains on his back. He stays there and holds him down. And you know, to Investigator Dallin, Mr. Mattioli says, "I knew he was breathing." That shows an awareness that what you're doing creates a substantial and unreasonable risk of death or great bodily harm. But what does he say to Officer Roach when asked, "Is he breathing?" "I don't know." He wasn't paying attention to what he was doing, even though he was aware of what he was doing created this risk. The 911 call, the body camera of Officer Roach, the picture you see is a man, Mr. Mattioli, who's angry, who's intoxicated, who has restrained and prevented Joel Acevedo from getting up, who didn't pay attention to what he was doing. And he was just on there. And there was no sign he was going to get up until the officer said, "Get off him." He had to say it a couple of times, "Get off him, officer." And as he's getting up, he sort of pushes off. He would have stayed there for who knows how long. And he knew what he was doing. He knew it was dangerous because he said so, but he wasn't acting to pay attention to the person he had restrained. That is criminally reckless conduct. Did the conduct show utter disregard for life? That is a factor question. In determining whether the circumstances of the conduct show utter disregard for life, you consider factors. You can consider, and I'll simply read it. These factors, what the defendant was doing, why the defendant was engaged in the conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances. Did Mr. Mattioli's conduct show any regard for the life of Joel Acevedo? In the back of that squad car to Investigator Dallin, his words were, when told he's in bad shape, Mr. Mattioli said, "I don't give a fuck what shape he's in." That's an acknowledgement. You don't care. You have no regard for the life of the person you've just restrained, for the life of the person who is held, for the life of the person you're relying on. There's no regard for what was going on. His conduct was not only criminally reckless, but showed utter disregard for life. It is the state's view that the elements of first-degree reckless homicide were committed by Mr. Mattioli. You also, though, have to consider, as the judge instructed you, these issues. Because on the evidence, these issues are there, and the state has the burden of proving that these are not applicable. You have to consider self-defense. You have to consider defense of others. You have to consider arrest. You have to consider an accident. Now, this was not an accident. That's simple. An accident would be Mr. Mattioli tripping and falling on Mr. Acevedo, maybe hitting his head and not being able to get up. That's an accident. These were volitional acts of Mr. Mattioli getting on Mr. Acevedo. It's not an accident. Under Wisconsin law, person can use force in self-defense or defense of others if the defendant believed there was an actual or imminent interference with his person and person of another. The interference on this evidence happened. Happened in that living room. The push, there was the hit. But then it's done. Self-defense doesn't let you then restrain a person for however long you want to. In fact, the words spoken by Mr. Acevedo when that 911 call is made are these. Let me go home. My score's not woke. I'm going home. Shortly thereafter, I swear I'll go home. I swear. Fucking. There's no longer any threat going on. Mr. Acevedo wants to leave. He wants to get out of there. And he's prevented from getting out there by Mr. Mattioli, who's simply angry. You hear that in the 911 call. Just anger. I mean, you saw a version of Mr. Mattioli on the stand yesterday. You saw and heard a different version on April 19th. That's the version that's important. It's not the version that's had 3.5 years to think about this. That morning, this was not, I'm in trouble, we're protecting him. This was simply anger to hold him down. This was not self-defense or defense of Mr. Peters. It's also not a legal arrest. First of all, you don't make an arrest when you're intoxicated. And second of all, when you arrest somebody, you're responsible for them. You have to watch out and make certain they're okay. That was not done by Mr. Mattioli. As he said, he didn't care what shape he's in. Simply didn't care. His actions were not reasonable. The defenses of self-defense, defense of others, reasonable lawful arrest and accident are not applicable. Now, as I said, there are two versions of Mr. Mattioli. There's a version you saw and the version then. You have to decide what happened that morning. What happened that morning was a man who was extremely angry, and his conduct is a substantial factor in causing the death of Joel Acevedo. His conduct was criminally reckless and showed utter disregard for the life of the person who was restrained. And based upon the evidence, the state asks you to find him guilty of first-degree reckless homicide. Thank you.
Thank you. The defense, Mr. Hart.
Thank you, Your Honor.
Thank you.
Please, the court. Mr. Tiffin. Good morning, ladies and gentlemen. When you took an oath to serve as jurors in this case, and when we talked in jury selection about following the law, you all assured me and the process that if selected as jurors in this case, you would take the evidence as presented in the courtroom, apply it to the law as instructed you by Judge Swanson, and then and only then reach a just and true verdict. If you apply that law as you've sworn an oath to do, you must find Michael Mattioli not guilty of both first-degree reckless homicide of Joel Acevedo and second-degree reckless homicide of Joel Acevedo. The facts in this trial are largely uncontroverted. You heard them from Mr. Peters, you heard them from Mr. Janowski, you heard them from Mr. Mattioli first when he told Investigator Dallin, and you heard them again live from Mr. Mattioli yesterday. In large part, each one of those stories is consistent, and the state hasn't provided any evidence to the contrary. On April 18th, 2020, Mr. Mattioli was at his home, in his own home, after inviting some of his friends to come over and sit by the fire. After an evening of partying and drinking to excess, to be sure, they all did the responsible thing and remained at Mr. Mattioli's home rather than get in an automobile. And Mr. Mattioli went upstairs and went to bed. You heard Mr. Tiffin just tell you that there were two versions of Mr. Mattioli. The version you heard on the tape and speaking to Investigator Dallin, and the Michael Mattioli you heard on the witness stand yesterday. I would submit that there are two versions of Joel Acevedo. The Joel Acevedo who came over to Mr. Mattioli's house at Mr. Mattioli's invitation. The Joel Acevedo that Mr. Mattioli befriended when the two of them were working at Northwestern Mutual Life. And contrast that with the cocaine-fueled, alcohol-fueled, aggressive Joel Acevedo that comes into Mr. Mattioli's bedroom and begins rifling through his pockets. Later, in an agitated way downstairs, strikes Mr. Mattioli first, then punches Mr. Peters in the face so loud that it popped and knocked Mr. Peters down the hall. That's a different Joel Acevedo than Mr. Mattioli had ever seen before, ever. The only difference between Mr. Acevedo the previous night and the next morning, we learned from Dr. Valentine, who tells you, based on his review of the toxicology reports and the urine and blood of Mr. Acevedo taken at St. Luke's Hospital the next day, there was high levels of cocaine metabolite running through his veins. And when Mr. Tiffin tells you that but for the conduct of Mr. Mattioli, Mr. Acevedo would be alive, think of it the other way. And that is, but for the conduct of Mr. Acevedo, Mr. Acevedo would be alive. Because Mr. Mattioli was having a party in his own home, inviting his friends over. He didn't ask for any of this. Mr. Mattioli didn't attack Mr. Acevedo until Mr. Acevedo attacked Mr. Mattioli and Mr. Peters. And what he did is defended them in his own home. This isn't a street fight. This isn't a fight Mr. Mattioli picked with as a bully. He's in bed minding his own business. When in comes Mr. Acevedo rummaging through his pockets. What? What are you, really? Mr. Mattioli tells him, what's going on? No, it's not what you think, Mr. Acevedo says. Well, your hand is in my pocket and I'm asleep. What else am I to think? You need to leave. You need to leave. You, sir, need to leave. This nonsense about Mr. Acevedo says, I want to leave. He wants to leave after he's punched two people and he knows he's about to be arrested. Yeah, I'm sure he wanted to leave. The time to do that had come and gone. And now you're going to have to leave in police custody because you committed a crime, at least one, probably more. That's this case. And so when we talk about reasonableness and self-defense and the right to arrest, all that exists. And the law, as instructed you by Judge Swanson, tells you. Mr. Mattioli, in his own home, has the lawful right to defend himself. He has the lawful right to defend his guests. He has the lawful right to arrest someone who's violated the law. And the judge told you that. And with respect to your decision, the law says, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Joel Acevedo by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life, which I'll argue in a moment, and the death of Mr. Acevedo was not an accident, which I'll get to, and that the defendant did not act in self-defense, and that the defendant did not act lawfully in defense of others, and that the defendant did not act lawfully in using force to make an arrest. You must find all of those things did not occur beyond a reasonable doubt in order for you to convict Mr. Mattioli of either charge. Go through that. Go through that analysis. But before you get there, you need to decide as a primary matter, did Michael Mattioli cause the death of Joel Acevedo? Did he cause it? And on that issue, you heard from Dr. Jensen. Dr. Jensen is a credentialed forensic pathologist that provided testimony from Mr. Tiffin's office for 20 years or better, in hundreds, if not thousands of cases, after conducting 5,000 or 6,000 autopsies. He is eminently qualified to render opinions on cause and manner of death. And he told you on the issue of what caused Mr. Acevedo's death the following. Mr. Acevedo died as a result of prone restraint, being on his stomach and being restrained by Mr. Mattioli, which is inherently safe in healthy individuals. Let me repeat that, because that is a critical opinion by Dr. Jensen. Prone restraint is an inherently safe maneuver in healthy individuals. The literature supports it, and his experience tells him that is true. He concluded, but for the conditions, Mr. Acevedo's obesity, Mr. Acevedo's smoking, Mr. Acevedo's cocaine, Mr. Acevedo's immunoglobulin deficiencies, which reduced his ability to fight infections, and the violent struggle with Mr. Mattioli, that is what caused his death. But for all of those things, Mr. Acevedo is still alive, is the opinion of the eminent forensic medical examiner in this trial. Uncontroverted testimony, uncontroverted. He would have survived, says Dr. Jensen, but for obesity, smoking, cocaine, immunoglobulin deficiency, and violent struggle. And so, when Mr. Tiffin tells you in his opening statement, you will have to decide, was this an accident or was this criminally reckless conduct? Think about Dr. Jensen's testimony on the issue of cause. And in terms of accident, Mr. Tiffin tells you it was a volitional act. It wasn't some by chance accident. No, the accident was the death. This was an accidental death. It wasn't an accidental encounter with Mr. Mattioli. It resulted in an accidental death based upon Mr. Acevedo's own conduct in striking Mr. Peters. That's the case. That's the case. And before you can find otherwise, you must be satisfied, beyond a reasonable doubt, that the state has proven it wasn't self-defense, it wasn't defense of others, it wasn't an accidental death, and Mr. Mattioli caused the death of Mr. Acevedo. You must make all of those findings beyond a reasonable doubt. The law also says, as Judge Swanson read to you, under the burden of proof in deciding whether Mr. Pippin has proven his case beyond a reasonable doubt, if you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so. What does that mean? Is it a reasonable hypothesis that a man of 25 years old with the most compromised lungs Dr. Pearl, the pulmonologist, almost has ever seen? These were severely compromised lungs. He had bad disease. There were moments in the last 2 or 3 years of his life where he was pushing out 24% of the oxygen necessary to keep him alive. He was compromised in a way very few others are. Mr. Mattioli had no idea of the lung compromise of Mr. Acevedo and how sick of a man he was. And so when you think about reasonableness and recklessness, Mr. Mattioli had no idea about the depths of Mr. Acevedo's lung condition. According to Dr. Pearl, his lung function was pretty awful. Those are Dr. Pearl's words. Asthmatics are already at a higher risk of infection. You were told that. And that the exercise or exertion can make a person with compromised lung disease at a significantly higher risk. According to Dr. Pearl, it is a matter of life or death. That's who Joel Acevedo was when he began lashing out and punching people in Mr. Mattioli's home. On the reasonable hypothesis, is it possible that these severely compromised lungs, coupled with the use and abuse of cocaine, the use and abuse of alcohol, the use and abuse of cigarettes, and the struggle with Mr. Mattioli brought about his death accidentally? The death was an accident. And you must find, in order to convict Mr. Mattioli, that the state has proven beyond a reasonable doubt that it wasn't. That Mr. Mattioli should have known of the badly scarred and compromised lungs of Mr. Acevedo. He couldn't possibly have known that. I don't really know what to tell you about Dr. Tolomak, except that she concedes that as a person with severely compromised lungs, Mr. Acevedo was more vulnerable than the average person. She finally conceded that. I know this about Dr. Tolomak. She didn't author a report. She reviewed the work of the pathologist, the medical examiner, Dr. Peterson, and ultimately she viewed some slides. She tells us that in her opinion, Mr. Acevedo suffered from neck compression. You heard from Dr. Jensen, there is no objective evidence to support that claim, none. So as you think about credibility, you'll have to think about Dr. Tolomak, who didn't author an opinion, didn't author a report, and Dr. Jensen, who is eminently qualified. Dr. Jensen tells you there is no objective evidence to support a claim that he suffered any deprivation, that he suffered any significant neck suppression that would cut off his airway or cut off oxygen to the brain. That's what Dr. Jensen told you about the neck compression issue. He also told you that the petechiae about Mr. Acevedo's body was a shawl on his arms, on his upper chest, and his thoracic region, which were indicative of chest and abdominal compression. Dr. Jensen tells you that Mr. Acevedo was medically frail, that he suffered from severe pulmonary compromise. He explained to you what ought to be obvious to most, that cocaine increases heart rate and blood pressure. That's the man who Mr. Mattioli encountered in his living room that day. A severely compromised and medically frail Mr. Acevedo, and he couldn't possibly have known it. He couldn't possibly. Dr. Jensen tells you that even with some amount of weight on the back, that the prone restraint is inherently safe, and that ultimately the cause of Mr. Acevedo's death was cardiac arrest. His heart gave out. His heart gave out because it was beating too fast from the cocaine, likely. His lungs gave out because it was severely compromised and occluded, as Dr. Kroll showed you in the diagram. It was occluded with infection that probably wasn't properly managed because he hadn't been getting these immunoglobulin shots back in 2019. And he had been involved in a violent struggle of his own making. There are no winners in this case. This is a tragedy beyond imagination. But the cause of it, and ultimately the cause of Mr. Acevedo's tragic death, was his own conduct. And Mike Mattioli didn't ask for any of it. Those are just the simple, hard facts. Mr. Mattioli acted reasonably. He acted lawfully. And he acted appropriately. His behavior after the fact, something different. But whether he was boorish, rude, obscene, vulgar, in speaking with Investigator Dallin for those 5 minutes after he was stewing in a car for 4 or 5 hours, that isn't part of your analysis. Those aren't the facts related to Mr. Acevedo's tragic death, or the law which governs your deliberations on whether a criminal act occurred or an accidental death occurred. And it would be more than a shame if you allowed Mr. Mattioli's boorish speech to Investigator Dallin to govern your ultimate decision in this case. Whether this was an accidental death or a crime is not even close. There are at least 4 reasons why the state has failed miserably to satisfy its burden beyond a reasonable doubt. I've laid them out for you. You've paid attention over the course of this week, and on behalf of Mr. Powell and Mr. Mattioli, we appreciate your willingness to serve. I'm asking, based on the law, you are duty-bound to follow. that you return verdicts of not guilty on the first-degree reckless homicide charge, as well as the second-degree reckless homicide charge. And in closing, I will say this. You and I, the judge, we all have the right to defend ourselves, perhaps the duty to defend our guests in our own home. That's what Mr. Mattioli did on the 18th and 19th. Didn't punch Mr. Acevedo, didn't kick Mr. Acevedo, didn't shoot Mr. Acevedo. His conduct was eminently reasonable and appropriate, and I would ask that you so find. Thank you.
Thank you. Mr. Tiffin?
I agree with Attorney Hart in this respect. His client's behavior with Mr. Dowling in the car should not be a reason to convict Mr. Mattioli. What's important is the words he said, not his behavior. The words he said, I'm told this guy's not in good shape. I don't care. There was no thought about what he did. That was it. The words that are important and the tone of the words in the 911 call shows a person not acting reasonably in self-defense, which will arrest him. It shows an angry human being who's not going to listen. And yes, Mr. Acevedo had all these conditions, but he had them for a while. It didn't prevent him from going to pub crawls. It didn't prevent him from working. It didn't prevent him from going to the party. It didn't prevent him from hitting Mr. Peters. Mr. Hart talked about all that, but ignored one thing that's important. His client climbing on his back and crushing his legs. Can't forget that. That's all part of the picture. I agree. Facts in this case are largely disputed. You have to decide whether or not the state can in the case beyond a reasonable doubt. The state simply asks you to take the evidence, all of the evidence, take the law. And based upon this, it's the state's position, you should be found guilty of the first degree reckless homicide. Thank you.
Thank you. Great. Ladies and gentlemen, now, final closing instruction. Members of the jury, the duties of counsel in the court have been performed. This case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind, and as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following three forms of verdict will be submitted to you concerning the charge against the defendant, Michael A. Mattioli. One reading. We, the jury, find the defendant, Michael A. Mattioli, not guilty. Another reading. We, the jury, find the defendant, Michael A. Mattioli, guilty of first-degree reckless homicide, as charged in the information. And the third reading. We, the jury, find the defendant, Michael A. Mattioli, guilty of second-degree reckless homicide, as charged in violation of Section 940.06 of the Criminal Code of Wisconsin, at the time and place charged in the information. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. You will be taking this binder with you back into deliberations. The verdict forms are under tab 1. These instructions are under tab 2. Again, remember, just execute one of the three forms of verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff, signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should consider and continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. At this time, I'm going to ask Madam Clerk to swear the officers. Madam Clerk.
Do you solemnly swear or affirm that you will keep all jurors on this trial together in some private place, and that you will not, before you render their verdict, communicate the state of their deliberations or the verdict they have agreed upon, so help you God, or under the pain or penalty of perjury? Thank you.
Thank you. Ladies and gentlemen, we still have 14 of you. So at this time, we're going to select the two alternates. The two alternates will not be joining the other jurors for deliberations, but you are on call if we have any sort of issue with the 12 jurors who remain for deliberations. So I'm going to ask you to remain available and by your cell phones until a verdict has been reached. Now, do all of you remember your original juror numbers? Okay, I see everyone nodding. Madam Clerk is going to randomly select two jurors as the alternates. Madam Clerk. Okay. Right. Juror number 24. Ma'am, thank you very much. Could you please state your name for the record? Okay, thank you, ma'am. Thank you for participating in this trial. You won't be joining the other jurors for deliberations, but thank you for your service. Juror number 28 is the second alternate. And sir, your name? Okay, Mr. Czar, thank you very much for your service. Again, you won't be joining your fellow jurors for deliberations. Please, you will be on call, though, for the duration of deliberations. You have completed your jury service at this time. Both of you will be leaving with the jury, but you won't be joining them for deliberations. You can pick up letters from the clerk's office if you wish. If you don't, those will be mailed to you in the near future, within the next week or so. Right. Thank you, everyone. At this time, I'm going to ask the jury to retire for deliberations. All rise for the jury, please.
Judge, can we approach?
Yes. Well, I'm going to ask the jury to retire. I'll talk with the attorneys. Attorneys? Attorneys, is there an issue? But I don't think there's anything else for the record, Mr. Tiffin.
No. Exhibits, I don't know, I guess I just wait and see if they want anything. Obviously, if they want to hear something, we have to be back in court. That's my position. I don't know what that comes as regarding the physical things, pictures.
Defense, regarding exhibits going back to the jury room, did you want to stipulate to any particular exhibits?
I'm always of the mind that I wouldn't send anything back until they ask. I'm sorry.
That's what I said.
Okay, that's fine. Well, and attorneys, please stay close. Make sure Madam Clerk has your cell phone numbers. We'll be contacting you if we receive questions from the jury.
Okay.
Thanks.
If we, there's always a possibility here, they might ask for recordings to be replaced. If you've got a couple, that can be done in a limited fashion.
That has to be done in open court.
Right. But,
Yes, yeah, the court's policy,
Yeah, only once or twice max.
so typically, yeah, only in open court with all parties present, and I would typically play the recording twice without stopping.
Very good. Thank you.
All right, thanks, everyone. All right, we're in recess. You ready? Okay. So we're not going to recall. Okay. All right, ladies and gentlemen, we're back on the record in this matter. It's 2:47 p.m. The court received a note from the jury. The time of the note is 2:19 p.m. I think we received it a little bit after that. I've discussed this note with the attorneys. The note reads as follows. No decision has been made. We are considered deadlocked. Dated today, signed by the foreperson. Under these circumstances, the typical procedure would be for the court to read what is known as Instruction 520, the supplemental instruction on agreement. It's also called the Allen instruction. Parties, with regard to that procedure, what are your positions? We'll start with the state. Mr. Tiffin.
The state is asking the court to read 520, the standard instruction that has been, as the comments state, it has been around since the early 60s. It has been approved by the Jury Instruction Committee. State's not asking for any changes to it. I think there's a benefit of any jury in any courtroom in this state hearing the same instructions. This is a fair and neutral statement of the law, and so the state would ask the court to read 520.
For the defense.
We're opposing the giving of 520 at all. I think the jury's deliberated now for about 4 hours at the time this question came out. The evidence in this case was not really voluminous. It took place over 3 partial days. No questions came out. They did not ask to see any exhibits. I think it's fair to infer that they have been debating the merits of the case from the beginning. And so I don't think an Allen instruction or the 520 instruction is warranted. I would say if the court's inclined to give it, however, I would have a request to modify its language.
Right, and Mr. Powell, I discussed with you and Mr. Hard and Mr. Tiffin in chambers the changes you're requesting. If you could just read the instruction you're requesting.
Yes, so the reason why for the amendments I'm proposing is that it's my view that 520, the pattern instruction, is not, in fact, a neutral statement to the jury or jurors. Its language, in my view, targets any juror who's in the minority of the position in the jury room. Now, we don't know what it is. We don't know what the count is, who's in favor of guilt, who's in favor of acquittal, 11-1, 6-6. We don't know any of those things. But the language that's concerning in the draft instruction states, quote, jurors should not be obstinate, they should be open-minded, and they should listen to the arguments of others, etc. But it's that phrase, should not be obstinate, and they should be open-minded, in my view, has a coercive nature to it because it has the effect of targeting people who are holding out. Let's say, just hypothetically, because we don't know, it's 9-3 or 10-2 or 11-1, one way or the other. Those people in the minority would fairly infer from that language that they're being accused of being obstinate because they're holding firm to a position against the majority. And that's why I think the pattern language is not appropriate and it's wrong. And so I would propose the following language, which largely mirrors the pattern, but gets rid of what I think are problematic phrases and reworks the instruction a little bit just to make sure they understand that they are not going to be held here until they agree, because that's not the way it's supposed to work either. They're to make an honest effort to agree. If they can't, they're not held until they do. So I believe it should read as follows. You jurors are as competent to decide the disputed issues of fact in this case as the next jury that may be called to determine such issues. It is your duty to make an honest and sincere attempt to arrive at a verdict. Jurors should listen to the arguments of others and talk matters over freely and fairly and make an honest effort to come to a conclusion on all of the issues presented to them. However, you are not going to be made to agree, nor are you going to be kept out until you do agree. You will please retire again to the jury room.
Thank you. And again, The court has already discussed this issue with the attorneys in chambers. Our discussion there mirrored the discussion we just had. After that discussion and reviewing the standard instruction, I agree with the state here that the standard instruction should be read. In looking at that instruction, it has been the standard instruction since the year 2000, so it's a well-established instruction. It's been used for many years in courts throughout the state. I disagree that it puts unfair pressure on minority jurors or jurors who might be in a minority position, rather within the jury. The language of the instruction itself is neutral, and it would apply to all jurors given a fair reading. So the court is going to read instruction 520 in the approved version, the version approved by the Committee on Jury Instructions. I'm going to ask the deputy to bring in the jury, please. Yes. Thanks. Please take your seats, everyone. Ladies and gentlemen, first, thank you for your continuing service. I did receive the note you sent, signed by the foreperson at 2:19 p.m. The note reads as follows. No decision has been made. We are considered deadlocked. I've discussed this with the parties, and after discussing with the parties, the court has decided to read to what is called a supplemental instruction on agreement. I'm just going to read that instruction at this time. You jurors are as competent to decide the disputed issues of fact in this case as the next jury that may be called to determine such issues. You are not going to be made to agree, nor are you going to be kept out until you do agree. It is your duty to make an honest and sincere attempt to arrive at a verdict. Jurors should not be obstinate. They should be open-minded. They should listen to the arguments of others and talk matters over freely and fairly, and make an honest effort to come to a conclusion on all of the issues presented to them. At this time, I will ask you to please retire again to the jury room. All rise for the jury. Please take your seats. Is there anything else for the record, Mr. Tiffin?
No.
Mr. Hart and Mr. Powell?
Nothing further.
Okay. Everyone, we are in recess again until we hear from the jury. right, good afternoon, everyone. We're back on the record. The court received notice from the jury that they had reached a verdict at about 3:20 p.m. We're back on the record at this time. I'm going to be bringing the jury in to read the verdict. I just want to remind everyone in the gallery, you cannot engage in any demonstrations. Obviously, some people will be very upset. Some people will be happy. I'm going to ask everyone to maintain your composure and leave the courtroom peacefully once this verdict is read. And ask the jury to come in, please. All rise. Yes. Thanks, everyone. Please take your seats. Members of the jury, the court received a notice that you had reached a verdict. That verdict form has been returned to the court. I'm going to read that verdict into the record now. After I read the verdict, I'm going to ask you to return to the jury room, where I'll be meeting with you in just a few minutes, okay? All right, folks. In the matter of the state of Wisconsin versus Michael A. Mattioli, we, the jury, find the defendant, Michael A. Mattioli, not guilty, dated this date, the 10th day of November, 2023, and signed by the foreperson. Thank you, ladies and gentlemen, for your service. I'm going to ask you to return to the jury room, please. All rise. Please take your seats. Post-verdict motions. Let's start with the state. Mr. Moore, the defense, rather, Mr. Hart.
Move for entry of judgment on the verdict, please.
For the state, Mr. Tiffin.
That's the appropriate, this was a jury call, they've made their decision.
The jury has made a decision here. The court does enter judgment on the verdict for the defense. And Mr. Mattioli, you are discharged. Ladies and gentlemen, at this point, this case is concluded. I'm going to ask everyone to leave the courtroom peacefully. I'm going to ask Mr. Acevedo's family and supporters to leave first. It would be best if we maintain separation between the parties until everyone has a chance to exit the building. All right, folks, court is adjourned.
committee will include it. Yes, sir. Okay. Yep. Yes, yes. The deputies can, they can explain. Yes, he's going.